A tenancy deposit scheme is a government authorised scheme. Its aim is to safeguard tenancy deposits, and it does this by preventing landlords unlawfully withholding or making deductions from a tenancy deposit at the end of a tenancy agreement. In England, the tenancy deposit scheme only applies to assured short-hold tenancy agreements. It's primarily governed by Chapter 4 of the Housing Act 2004. Under that Act, a landlord has two main obligations should they receive a tenancy deposit in connection with an assured short-hold tenancy agreement. The first obligation is the landlord must ensure the tenancy deposit is protected with a government authorised scheme within 30 days of that tenancy deposit having been received. The second obligation is the landlord must ensure the tenant is provided with the prescribed information relating to the tenancy deposit scheme within 30 days of receiving the tenancy deposit. Now, if a third party paid the tenancy deposit on behalf of the tenant, that third party must also be served with the prescribed information. Now, if any or all of those obligations have not been complied with by the landlord, there are two consequences. First of all, the landlord will not be able to serve the tenant with a Section 21 notice under the Housing Act 1988. That's the no-fault eviction ground for possession, and it's very wise landlords keep that option open to them in the event they need their property back. Now, the most common way of lifting the restriction on serving a Section 21 notice in that instance would be to simply return the tenancy deposit to the tenant in full. Now, in other cases, if there's rent arrears outstanding, as an example, the landlord may want to offer the tenant to use their deposit in full to cover those rent arrears. And if that results in the landlord no longer holding a tenancy deposit, then that would also achieve the landlord lifting the restriction on serving a Section 21 notice. The other consequence for the landlord is that the tenant may bring a claim against them, seeking payment of 1 to 3 times the value of the tenancy deposit for the landlord's breach of the tenancy deposit scheme requirements. That claim can also be brought against a letting agent. Now, there should be no assumption that the tenant would automatically be entitled to 3 times the value of the tenancy deposit if a breach has occurred. The most relevant factor when considering what amount of money the tenant could be entitled to is the culpability of the landlord, the culpability for the breach that's been committed. And this was determined by a High Court in 2014 in a case where the landlord failed to protect the tenancy deposit within 30 days, although it was eventually protected. In this case, the County Court decided that the tenant was entitled to 1 times the value of the tenancy deposit. And it reached that conclusion on the basis that the judge found the landlord's culpability for the breach he'd made was at the lowest end of the scale of culpability. The judge made that finding on the basis that the landlord had proven that he had relied on a letting agent who had let him down. And as soon as he'd found out that he'd breached the tenancy deposit scheme requirements as a result of this letting agent having let him down, he'd then complied as much as he could by protecting the deposit, although it was protected out of time. So that mitigated the breach. This then was appealed to the High Court, and the High Court judge agreed with the Court of First Instance that the most relevant factor was the culpability of the landlord. So this shows us that if a landlord has not protected a deposit within 30 days, or if the prescribed information was not provided to the tenant or any third party that paid the tenancy deposit on behalf of the tenant within the 30-day requirement, action can be taken to mitigate the breach and lower the culpability of the landlord. Now, that's just one of the partial defences that could be available to a landlord, where a tenant is claiming 3 times the value of the tenancy deposit. The first defence is to argue that the tenant is not entitled to 3 times the value of the deposit if it is accepted that a breach has in fact occurred. Another defence that could be available to the landlord is that the landlord is entitled to set off the amount of money the tenant is claiming against the landlord's claim against the tenant, known as a counterclaim. This could be for unpaid rent or other damages that the landlord may wish to claim from the tenant. If a tenant is claiming 3 times the value of a £500 deposit, the value of the tenant's claim is £1,500. But if there are rent arrears outstanding of £2,000, part of the landlord's defence could be that the landlord is bringing a counterclaim which would set off any amount of money the tenant could be awarded for the landlord's breach of the tenancy deposit scheme requirements. So there are defences available to landlords who are facing a claim by a tenant for failing to comply with the tenancy deposit scheme requirements. So if you're a landlord or a letting agent and you have received a letter from a tenant or somebody acting for a tenant claiming a payment for an alleged breach of the tenancy deposit scheme requirements, do contact our team and we'll be able to assess whether you have a defence available to you.